Hello, everyone. Thank you for joining us here today. My name is Quinn, and we appreciate you joining us for the PTAB Masters program, the virtual program, which we have another judges panel in store for us here in this hour. We'll get going here momentarily. We'll just give a few seconds to let everybody get from the waiting room into the panel room here. Our numbers are growing pretty rapidly. Thank you all for spending a portion of your day with us today. The panel we're going to have right now is inside the PTAB, former PTAB judges on the future of AIA trials. This is, I think, largely going to pick up on the conversation we just had, which was a former judges panel on, where are we right now and what's going on right now. And certainly if this panel has any thoughts on that, we can address those as well. But want to also try and give some actionable information and ideas about what it is that you all can and should be doing moving forward in this, I guess it's probably fair to say, a new reality. So with that brief introduction, let me thank our sponsors. We have a lot of great sponsors here today. We really appreciate them. We couldn't do this without their support. And I will kick it over to Renee to introduce the panel. Renee.
Thanks, Jean. Welcome, everybody. We're happy to have you here. Today on our panel, we have Jennifer Bisk. She's a senior patent counsel at Unified Patents and a former administrative patent judge with over a decade at the PTAB. She presided over some of the earliest AIA trials and brings deep experience across PTAB proceedings, supported by a strong technical background in computer science and engineering. Next, we have Tim Fink. He's a partner at O'Melveny and Myers and a former vice chief judge of the PTAB and senior legal advisor to the USPTO director. With a background as an electrical engineer and extensive experience in high-stakes patent litigation, Tim brings a practical, policy-informed perspective on PTAB and district court practice. Next, we have James Moore. He is Of-Counsel at Buchanan, Ingersoll, and Rooney, and served more than 20 years as an administrative patent judge at the PTAB, including as acting chief judge. With experience across appeals, interferences, and AIA trials, he brings a thoughtful, practical approach shaped by decades of service. And last but not least, we have Scott Weidenfeller. He is a partner at Covington and Burling and a former vice chief administrative patent judge at the PTAB. He played a central role in implementing major Supreme Court decisions affecting post-grant proceedings and previously served in the USPTO Solicitor's Office. Scott brings unmatched insight into PTAB policy, litigation, and appellate strategy. Back to you, Jean.
Great. Thanks a lot, Renee. And again, thank you all for being here. This is a CLE hour. We have the CLE materials posted on the panel page on IPWatchdog. And we will have several poll questions that will pop up throughout our conversation. So it will give us some opportunity to verify you were here if you would take those poll questions and answer them, even if the answer is simply, leave me alone, I'm only here for the free CLE. That will register and we'll still know that you are here. So with that introduction, what I'd like to do is pick up where the last panel left. Well, actually, first, before we do that, why don't let's go around the table. And without me asking any questions of you, just give you the opportunity to say, what's on your mind, set the theme that you want to address, pick up on what the previous panel said, riff on something that's of consequence to you, open mic opportunity, and we can go. Let's start with ladies first. Jen, how about we start with you?
Okay. So what I've been thinking about watching the previous panels today is there's been a lot of talk about what the office can do efficiently. How do we make the whole system better? And I just wanted to give my perspective on kind of what I thought AIA was about. I was hired right after AIA passed, and I was right there at the beginning of all of the implementation of trials. And the policy feeling that I got of what IPRs were trying to do was that everybody knows that examiners have only a very limited time to do searches and to look at the prior art and to decide if something is obvious. And so there's going to be things that they don't find. There's definitely going to be, they don't run like Coke was talking about with you earlier. They don't do the hundreds of hours of searches and hire lots of attorneys to do their searches for them. Obviously, they don't have time for that. So in order to make patents, to make the quality correct, we either have to give examiners a lot more time and make it more expensive to get patents, which we, I think, as a society decided is not what we want to do. We want to make entry level easy so that people don't have to have a huge company and an army of lawyers in order to get a patent. At the same time, because we're not doing such a thorough examination, there's going to be patents that get out that are obvious. And that's just how it goes. That's the bargain that we're making. So there has to be a way. And before AIA, there were three ways, right? There's ex parte re-exam, there was inter partes re-exam, and there was the district court in order to figure out if the patent that's being litigated is one that got past the quality controls, and because of the fact that there's not a lot of time for examination. And I think the thinking was, well, most patents do not get litigated. Most patents don't get asserted against anybody. They sit and people are proud of them and maybe they use them, but they don't ever assert them against anyone. The ones that do get asserted are a very small minority, and those patents maybe deserve a second look. If you're going to start suing people on your patents, then you're not just, it's not just a right of yours, it's a right of everybody in the public who's getting sued and having to pay the price of something they use getting sued. And in those cases, it might be worth spending a little bit more money at the patent office and for the parties to take a closer look at these patents. And I think that's what IPRs were supposed to do. Now, whether that worked perfectly or not, I'm not a policymaker, I'm not a politician, I don't know. But to me, it seems like before IPRs, we had inter partes re-exam, we had district court, and somebody, at least a majority of people in Congress, decided that wasn't quite enough. So they added IPRs and got rid of inter partes re-exams. And now it seems to be going the other way. We're almost getting rid of IPRs, but now we only have district court and ex parte re-exam. And I'm very unclear about what has changed in our examination proceedings that make this a good move. Examination, they're actually getting less time now for each patent. And I think if you talk to any examiner, they'll say that their time to look at each patent is going down. So I think we're going to get more patents out that have smaller quality or less quality and fewer places to challenge them. District court, which is very expensive and includes a jury, and ex parte re-exam, which, only gets the patent owner involved. Maybe that's enough, but I don't know that what's going on right now has allowed a full enough discussion to get rid of it. That's just my thoughts.
Okay, great. Thanks a lot, Jen. Jay, let's go to you next. Open mic opportunity to comment on what Jen just said, or maybe the first panel, or plant some seeds on what you might want to say coming up here in this panel.
Thanks, Gene. First off, let me say it's a real pleasure to be here. And of course, my comments are my own only, not my employers. So I guess Judge Tierney said something in the prior panel which I wanted to hit on, which kind of is a theme I think is important, is that patentability is the issue here, right? That's the important part. And you asked that very same question yourself, Gene. It's what about the issues of patentability and subject matter and all that? And what the current controversy over is access to ways to determine the patentability, right? So we've had historically, interferences all along for many, many years. They're not here, of course. I mean, there are a couple left, one or two, I imagine, but those are no longer available. Inter partes re-exams have gone by the wayside, and I would argue, contrary to the deputy director's viewpoint, that those were horrifically structured with multiple reply briefs, filed by multiple parties, made them almost incomprehensible at various times. So those didn't really get the job done. So the AIA came along and we did implement that, and it provides a different set of approaches, PGRs, IPRs, and everyone's forgotten about derivations, but those are still out there. And all of these are ways to access it, and I think it's pretty clear that the statutes are written to, encourage at least access, the ability to do this, right? Any person may, right, can file these things. Whether or not the director acts on them, the director has tons of discretion as to how to approach it. It's even written into the statute. You got parallel proceedings, you got things going on for, you can figure out how you want to do that. But the real question, I guess, is how much do you want to restrict the access to determining the patentability? Because as Jen said, there are those patents that just get out there. Nobody has the resources to be perfect, and nobody's expecting a patent examiner to be perfect. But Congress, I think, is sort of the important factor here. Is they set it up. They want these things to be at least available. And I'd like to move the discussion in the zone of, well, how available should they be? Is throwing the policy into reverse at 100 miles per hour the way to approach it, or is there a better, more measured way to approach it?
Okay, excellent. Hopefully we'll have some time to talk about that, because I think that's the $64,000 question. Although today with inflation, maybe it's a $64 million question, but it's something that really, I think, not enough time is being spent talking about in a serious way. I know there's legislation pending and so forth, but I do think there's probably better ways to go about a whole bunch of this stuff. All right, thanks a lot, Jay. Tim, let's go to you next for your initial thoughts.
Sure. I think Jen made a very good case for why there is a second look process in place, and from the economic point of view, I recall talking about this in law school, like why is there a re-exam, and it's like, is it practical to spend 100 hours examining something like 500,000 applications a year when only about fewer than 1% of them actually get litigated, and putting all that cost up front. And so I think that is what drives the policies on post grant and reexamination review, and I think those were, I don't know what's changed that would make those the economic policies that went into that thinking by Congress, what was changed about examination that would make that make that less accessible. The second look. The other thing I would just pivot to is, I think a big part of patent office practice that's been overlooked is just the predictability of it. So those of us that were involved in PTAB and inherited, I came later, but inherited years of precedent, was that there was a lot of attention paid by both the judges, but also the leadership of the patent office, to just kind of making predictable rules. Now you could argue that some of the rules were less predictable than others. Vintiv was a bit of a challenge, but overall making case law and precedent that was fairly predictable. And I think that's become much more challenging when you've made it, when you've thrown in more equitable considerations, when you want patent owners and petitioners to tell a story as to why they should or should not be there. It becomes much more subjective, right? It's we're all lawyers. We can all write good narratives to support our clients in most cases, right? Is it really, should it really come down to who's the better storyteller? We don't always have a clear-cut fact that we could point to and say, yeah, you don't have a settled expectation, and I should have the settled expectation. No, usually, you could argue that everybody's got settled expectations. I got settled expectations that there's a statute. You have settled expectations. You have a patent. And that lack of predictability is, that's tough to navigate for all parties, I think, at this time, and that's tough to. I think that's tough to bring back. If that's the way it's going to be going forward.
Okay, great. Thanks. I have some thoughts about that because I think that starts to get us into obviousness. I'll hold off on that until we get through this round robin here, though, and we'll give Scott an opportunity to give your final thoughts. Or your first thought, your the final one to give your first initial thoughts. So, Scott, table's wide open. Whatever you want to react to.
Yeah, thanks. And it's hard to follow these three people. So they've covered a lot of what I wanted to cover. But I think going back to what Jen was saying, there's a system where we want to incentivize disclosure of innovation. So we want to make it as inexpensive as possible for someone to get in the door of the patent office and disclose their invention to the public. And then we want to make it, relatively inexpensive for them to be rewarded for that and get a patent. And so we end up with this process that really no one in their right mind would set up an ex parte process where the examiner has resource constraints as the way to create the best, most accurate, most valid patent claims. It's designed to incentivize people to come in the front door, incentivize those who came in the front door and work with an examiner to get a patent that they can be proud of and use. And then we have this back end system that, starting in the 1980s with ex parte re-exam, it's been, well, maybe this has been a little too easy and these patents are out there when they become important enough for someone to spend the money to re-examine it, they'll do that. There were problems with ex parte re-exam because it was just the patent owner there and an examiner, and the accused infringer wanted to be able to speak beyond just the petition or the request rather. So inter partes re-exam had many problems, very time consuming, as we heard about in the earlier panels. And so the IPR was meant to be, we used to have, or we still have, the board on the ex parte side is providing a quality check on examiners who reject patent claims. But there's no sort of board coming in and doing the same thing on the granting side. So why don't we have them do that with this inter partes review? And because the petitioner here wants to have a way to speak, it's inter partes. And so that they set this up as a way to really go at the ones that are valuable and most least of the lowest quality for someone to actually spend all this money. So the numbers that we're seeing being high numbers of finding claims unpatentable are not particularly shocking, given that there's this much more rigorous process that they're going through. And why is it a more rigorous process? Well, it's because it's valuable enough that someone is willing to spend the money to enforce the patent. They're willing to spend the money to defend themselves against the enforcement of the patent. They're not just settling and saying, okay, well, you actually have a really good patent, I'll take a license to it. They're fighting it, and there's a real dispute about patentability. And so that's how we got here into these numbers of people claiming to be surprised that the IPR system is finding claims unpatentable. I mean, it really looks, last fiscal year, it looked at 300, they issued 366 final written decisions. That's, about a third of what the patent office issues in a given day. It issues about 360 some thousand patents a year. And so it's really just 1 out of 1,000 are actually getting all the way through to final. And there's no reason to be surprised that they're not the best of the best, because the other 999 are either less valuable or stronger, and so no one is willing to spend the money to challenge it. And so I think that's a system where obviously patent owners don't like it. And I understand why patent owners don't like it. And I have clients who are patent owners, and I don't like it along with them. But it is, meant to serve quality. And what I'm seeing now is we're using the tool of discretionary denial to get rid of these IPRs. The director is instituting about 70% of IPRs that are actually considered on the merits. That's the same number the PTAB was doing before the director took it over. So the director is saying 7 out of 10 patents that I see, that I look are at least one claim. There's a reasonable likelihood that it's unpatentable. There's something good in the petition. Now, the deputy director earlier said, well, maybe that shouldn't be the standard. That is the standard in the statute, is at least one claim unpatentable. That's what Congress gave the PTAB and what Congress gave the PTO. So that's what they have to decide. And so 70% of the time they're finding that. But what we're doing is, instead of saying, how do we fix that? What's what's wrong with the system that 70% of these are no good? We're just saying, you know what? I'm not going to look at 60% of those. I'm just not going to look at them. I'm not going to consider the merits at all. It could be the absolute worst patent ever, but it's been out there for more than 6 years. So I'm just not going to look at it. And it just seems like a bizarre way to set up a system where, a patent owner who sits on his rights for 6 years, does nothing, suddenly has a completely unchallengeable patent because it's just been out for 6 years. And it's not I heard a lot from the deputy director about someone who's been using it and doing all these things, licensing and things. And that's real set of expectations. But a 6-year bright line, I know that they say it's not completely bright, but it seems pretty bright to me. 6-year cutoff doesn't seem like the right way to do it to me.
Mm-hmm. Well, I'll just point out that on the trademark side, it's 5 years, and the trademark can last forever. Where the patent, lasts, most of them last 8 years. So it's not. But I don't want to get too sidetracked here. But I do want to go back to something that Terry Ray brought up. And Scott, I'll go to you first since I went to you last. So I'll let you define this conversation around this, so you don't have to look for something, or the others will have to come up with something original to say for this one. But Terry asked at the very end, in her final thoughts, are we on the right track? And I think what she was getting at is that, the USPTO, she even said this, is America's innovation agency, and that's the goal, is to enhance and promote innovation. And we're probably not going to know for a number of years whether or not any of this was good, in that, did it enhance innovation? Did it create more innovation? Did it create more companies? Did it create more investment? All those things that we want out of a patent system. So she just asked the question, are we on the right track? So I'd like to ask you all that question based on your view, maybe based on what your clients are telling you and what you're seeing in the industry. Are we, Scott?
So I think, as people have been suggesting, and I think time will have to tell. We'll have to see how things go, and what, we won't know for a long time. I'm still not sure we know whether we were on the right track starting from when the AIA was enacted, because it's been a relatively short period in the scheme of things. But so we'll have to look back. But I think that one of the earliest indicators we have is application filings, and patent application filings are down. I've been hearing that people were dissuaded from filing patent applications at the patent office because the PTAB was too aggressively killing patents, that everyone was going to trade secrets. Well, suddenly we're a year in now with changing, so things are very much more pro patent owner, and patent applicants are not filing as many applications. They're down for the first time in a very long time. And that doesn't seem like the right path to me. I think that we want more disclosure. We want more people using the patent system. And I'm concerned that we're going about it the wrong way. I think that, to Jen's point about cutting back examiners' resources to examine patents, doesn't seem like going the right way. And, it seems like I can understand and appreciate the concerns about maybe the PTAB being aggressive, but instead of focusing on the particular areas where they might be too aggressive, we're just saying, you know what, I'm just not going to look at 60% of these IPR petitions that come in. Doesn't seem like the right way to go about doing it to me.
Okay. Tim, you want to go next?
Uh,
Are
so
we on the right
the
path?
question is, or maybe you could reframe the question.
Yeah. So the question is in your opinion, do you think we're on the right path to be promoting that which the USPTO is historically intended to promote? You know, more innovation, greater economic activity, etc.
Yeah, I mean, I think it's a really hard question to answer, and I know that sounds like a cop out, but that's because it is. But it I mean, it's hard to know whether or not, there's the causation correlation fallacy, and
Yeah, and
whether or
I'll
not,
admit that I'm asking you
yeah.
guys to play, a little bit of, Kreskin and predict the future here, and it's not easy to do, and I mean even like with the applications being down, I suppose technically if they are down, but then there was a bubble with the fees, so depending upon what time frame you're shifting this. It may not be down, or it may be down a little, or it may, so much of this requires time and to look back. But I guess what I'm trying to get at is maybe the way to ask this is, are you comfortable with the path that, and since this is about the PTAB, that the PTAB is on, yes or no, I guess.
It seems like a different question, but
And maybe it
I'll
is, and
answer it.
I'm trying to make it so that it's less maybe asking you to play psychic
Yeah.
and more a little bit personal. And and if that's not a fair question, I mean we could just move on, because I don't want to get too bogged down, but I do think we want to try and give some people some ideas about the future. Maybe that's the thing to do, maybe just to move past that and to start talking about some of the substantive issues.
Yeah, I mean, I agree with you, and I think that's kind of why I brought up the predictability point, right?
Mm-hmm.
Because I think you know, having standards that people can kind of tailor their decisions to, and knowing what they are in advance, and being able to rely on them is a big part of that. So, I think that's uh one of the reasons I brought that up is I think, where you have 60% of, I think that's probably the right number, 60 or so percent denied for discretionary reasons, where the merits don't really seem to be that important, means that you have a huge number of potentially uh, poor quality uh, inventions that are getting through to the trials, um, where in most cases it's in many courts there's not a viable invalidity defense.
Mm-hmm. Okay. Well, I don't want to put you guys on the, ask you to do something we can't really do. And maybe the pivot here is now to get away from making these kinds of predictions, asking that kind of a question, to getting into the more specifics about some of these issues. And Jay, I'll turn to you, and Jen, I'd like to get your thoughts on this as well, about the real party and interest issue. I think that was during our pre-call. That was the one that took up the most of our time, and maybe has, I would say, perhaps one of the larger changes maybe moving forward. I don't know whether you agree with that, but Jay, your thoughts on that, because the director has made some of that either precedential or informative, right?
Yes, you have caught me, because I had organized all my thoughts to the question, and now you've changed
Well, no, if
it.
you want to, if you want to go back and answer that question, I saw the way that Tim was looking at me. It's got to some extent too, and and I realize I'm asking you to make a prediction. And the one thing that we know about predictions is they're always sure to go wrong. They're maybe fun to talk about, but if you want to make a prediction, please go for it. Are we on the right path?
Well, are we on the right path? I'll tell you what. In my history, I've got, if you look behind me, I've got my ego wall back there, or my love me wall, or whatever you want to call it, and I was having a discussion with my wife the other day, and she said, the most important thing on that wall is your patent. Because I am an inventor. I filed a sole inventor, obtained a patent, monetized it. I sold it to an industrial conglomerate, and they paid me for it. And so I really like the idea of strong patents, having them available, and I want to keep focused on that. So, are we headed in the right direction for that model? I mean, if my patent was patentable, yeah, I would love to be compensated for it, and I believe I was. But then again, if I filed a patent application and I didn't think it was patentable, but nonetheless I managed to persuade the agency to let it out, I wouldn't want that. I arguably might have a self-interest to go out there and start harassing people to get a settlement. So I think the whole reason the AIA passed was to give a relief valve to that sort of thing. And, maybe we shouldn't have the relief valve constantly changing. Maybe the relief valve should be set by statute. And, maybe the director shall institute provided certain things have been met, and the Congress could lay those out. And I think I would like to see this as an educated, intelligent discussion versus everybody's corrupt, or these people are evil, or that's wrong, or the judges are all biased. And in particular, there's one thing that the deputy director said this morning, said they're like building inspectors, right? The judges at the PTAB, they're there to do is to find something wrong. And that's not true. They're judges, much like judges in federal district court are. You have a plaintiff and you have a defendant, arguably different names, but and they're there to weigh the evidence and determine what the evidence says, and then go against the law, and then see if it's patentable or not. And on by and large, on a de novo legal review at the federal circuit, that's correct. They're found to be correct. And I would love to just be able to take the discussion out of the people who are on LinkedIn screaming at each other and just say, look, the issue is this. What's good for the economy? What's good for the U.S. going forward? How can we make our country, move this intellectual property discussion towards, there needs to be a relief valve. Let's make it a sensible one. Let's not call it destroying innovation. Let's not call it destroying investment. It's none of those things. There's a problem. It was addressed. Maybe it wasn't perfect, but the issue is and always should be patentability. Mm-hmm. Sorry, I'm on my high horse again. Gene.
No, that's fine. I mean, because you're getting us going here, I think, in earnest, and this brings up, I think, something that Scott was talking about as well. And one of the things, so let me push back a little bit, and nothing you guys haven't heard me say before, although I'll put a little different context on its spin probably. I have a friend who does mostly, actually pretty much only patent owner side representation at the PTAB. And years ago, he told me, he's like, I don't really know why most people are shocked picking up, like what Scott was saying about when a petitioner is willing to pay $500,000 to $1 million, in that range for filing fees, attorney's fees, and to see this all the way through the search and all that sort of thing. Most of these patents are going to fall. Simply just even good patents are going to fall because how much did they pay you? Maybe not good, let me say good innovations are going to fall because how much do they pay you in order to get the patent in the first place? And it's like 5 to 10% or less in some cases than what it costs, what they're willing to pay to invalidate it, and it's like, it's the difference between swinging a little tiny hammer you might use to fix a watch versus swinging a sledgehammer, right? I mean, one is going to get the job done much quicker than another one if you're trying to drive something into the ground. And I think that patent owners would feel like that's what's going on. And there are a lot of reasons why this is happening. And I don't think enough people are asking that question that you just asked, I think, which is this better? Is it right? Is it appropriate? And I think getting help from Congress is just not going to happen. So before I go to Jen, since you wound me up, I'll kick it back to you to get your thoughts. Anything there?
I would love to say that Congress is going to pick this up and do the right thing, but I agree with you, Gene. I don't think much is going to happen there.
Yeah.
But I'm also worried that the federal circuit and the U.S. courts aren't going to take the ball and run with it either.
No.
Yeah, on one of your recent panels, and not that recent, but Judge Newman was talking about disbanding the federal circuit, and
hmm
for a former, or actually, active federal circuit judge to say something like that just scares the heck out of me. That the system could arguably be that far out of kilter, and I want to bring it back to a rational discussion.
Yeah. Okay, great. Thanks a lot, Jay. And Jen, I know there's a lot on the table. I don't want to pigeonhole you. If there's anything you want to respond to or react to, just the microphone is yours.
Well, I don't really have any predictions of the future. I was a judge for so long. I kind of still have my judge hat on in some ways. I just left the patent office in November. But what I would say about where the PTAB should go in the future, or where the patent office should go in the future as for post-grant reviews, is I do think that one of the good things that we really had with IPRs was everything that we did, we wrote it down and explained it. Whether you agreed with it or not, at least it was there. And I'm a little worried about not having that explanation now. For instance, discretionary denials. I guess there were 600 decisions written, but a lot of them were very short. And if you go into the actual briefing and read the briefing, you see a lot more points by each side than is dealt with in the decision. And I think that leaves a lot of questions open about, well, what is this is the time of the patent the only thing that's important? Because they didn't address other petitioners' other points from the brief. It's really hard to say. So I think I would rather err on writing too much, being too transparent, than not enough. And I don't think that's where we are now. So I would like to go back to having more of the decisions written out, I guess, I think would be a good thing.
Mm-hmm. Okay. Well, good. I mean, I think we're off to the races here now. We got everybody's juices going. So let's just take a step back and do something easy, like talk about real party and interest. You're supposed to smile there. Because this, I think, is something that has been an issue in the minds of a lot of people for a long time. And whatever you think the answer is, it's my understanding that things, at least in your opinion, based on our pre-call, are changing with respect to the way that that's being handled by the board. Would you all agree with that? Did I get that sentiment correct? Okay, so Tim, I see you shaking your head most vociferously, so I'll go to you first. What can you tell us about real party and interest, the way that it's being handled today, and how that may differ, do you think, from the past?
Well, it's interesting because it's actually kind of returned to the past. So there was and I can maybe just give a little history too.
Sure, please.
While I'm at it, the real party and interest requirement on the petitioner is found in the statute, section 312, and the requirement to name real parties and interest, and it's along with the requirement to pay the fee, and a few other things that petitioners need to do. And fairly early on, there came a series of cases where the patent owners said, well, you didn't name all your real parties and interests, and therefore your petition is defective. It doesn't comply with the statute. It should be terminated. And I think the high water mark of that might have been around 2015 with the I believe it was the Corning case. And there was a decision that essentially held that Corning and Nate had not named. If I'm wrong about the party, I apologize, but they didn't name all of the real parties and interests. The panel did a very deep dive into corporate structure of Corning and said, yes, we agree, and we terminate the proceeding. And then starting in around a year or two later, and I think around there was a bit of a split of authority on the board, and I think the board started to move towards this opinion that the statutory language was not jurisdictional as to and that requirement was a disclosure requirement that did not create an independent basis for finding a petition defective. And there was a case called Lumentum Holdings, which was made precedential, and that eventually got to the Federal Circuit, and the Federal Circuit agreed with the precedential holding of Lumentum Holdings, which is that real parties and interests could be updated. You didn't lose your filing date, your petition wasn't defective, it didn't need to be terminated. The Federal Circuit agreed with that in a precedential decision called Maine Pharmaceutical, I think was the name of the case. Agreed with the PTAB on that, and so nevertheless the PTAB continued to kind of entertain these real party and interest discussions, and and I would say the vast majority of cases there was nothing really that flowed. There was no argument that the real party and interest, the failure to name all the real parties and interest or to keep them updated was somehow material to the case, other than the fact that other than the fact you didn't do it. And so, if you think about it in terms of like, why is there this real party and interest requirement? Well, it's mainly to make sure that the estoppel is complied with, that I can't turn around, I can't lose an IPR, turn around and give it to my subsidiary and say, now you try one. Or I can't pay somebody else to do one and say, okay, well, I failed, so there are cases on this. I don't remember all the names, but there were cases where you fail an IPR and you turn around and you fund somebody else to, and so those were cases where estoppel should have applied or a time bar should have applied. And so those were legitimately important real party and interest cases. But I think the idea that the board would just, every time someone said, okay, you didn't name all your real parties and interest, let's do a deep dive, when there was nothing else that really flowed from that, coupled with the fact that it's not a jurisdictional requirement, meant that kind of the board was wasting its time a little bit on that. Mm-hmm. It was a bit basic, kind of a witch hunt on the part of trying to a gotcha. Let me call it a gotcha. The board made a case called Shark Ninja precedential in 2020, I think it was, under Andre Yanku. And Shark Ninja said, look, if there's no consequence that flows from an argument, a dispute about real party and interest, we're not going to handle that anymore. And that sort of ended the majority of real party and interest arguments. This year, or 2025, Shark Ninja was de-designated as precedential, and the Corning case, which from 2015, was made precedential. And so now we kind of have a mixture of precedent between the PTAB and the Federal Circuit. Corning dismissed a petition because Corning forgot to name or didn't name a subsidiary as a real party and interest. Is that really, that means it's sort of a jurisdictional requirement as far as the PTAB is concerned. We still have precedent like Lumentum Holdings, and I think Propent is also another case that's on the books as precedent that says it's not jurisdictional. The Federal Circuit said it's not jurisdictional. And so now where are we? And then there was recently a case called Yangtze versus Micron that was made informative, where it appears that it is a jurisdictional requirement again. So it seems like we're back to using RPI as another kind of hurdle or another kind of pitfall for the petition, even when there's not necessarily an argument that the petitioner did anything or that there's any consequence to not naming them. So long build up, but I think we're at a place where it's to go back to my other theme, unpredictable.
Yeah, unpredictability is really, it's become a feature of the PTAB, there's a lot of reasons for that, but it does seem like, you don't have to limit it to this administration. I mean, you have, even during President Obama's term, you had sort of the patent office that was in the first term, and then you had the patent office that was in the second term, and then we've been flip-flopping presidents and philosophies, and it's whiplash type situation. Jay, let me go to you. I mean, because you were, when you were vice chief, you were kind of, as I understand it, really the day-to-day in charge of managing the board and the judges, and to the extent that you kind of facilitate them, I suppose is probably the best way to say it. But you were hands-on in charge of that sort of stuff, and then you were acting chief for a while. And from your perspective, as one of the early leaders of the PTAB, what does this do? I mean, I'm probably putting it hopefully on a T for you there, just to explain to people what type of administrative nightmare this creates.
Well, let me tell you, Gene, the PTAB judges are really, really good at determining issues of patentability when faced with prior art and the legal basis for that, and testimony on both sides as to whether or not the case is obvious, anticipated, patentable subject matter. They're just animals with it. They get it and they understand it. When you wander into an area such as a business structure, such as the Cornell case that Tim was talking about, that case is so wrongly decided, it's not even funny. There's just no way the board understood that in a multinational, thousands of different business units in it, that one remotely owned company that has no interest whatsoever in what another one remotely owned, but ultimately winding up under the same umbrella, it has no interest in what's going on there and doesn't care. And in fact, there's almost nothing in common. Well, the judges shouldn't have to delve, the patent judges, that's not their strong suit, to delve through all the corporate structure stuff. So you end up with your judges spending way too much time on these kind of issues. And to Tim's point, it's just, that's not the efficient use of the resources. And also, when someone reaches out for help, like, we don't understand where we should go with this, then you've got senior management kind of trying to figure, well, we need to figure out how this works. And then the ne plus ultra is, well, we better talk to the director to figure out, how we should decide something. It's just something you just don't ever want to be there, because the judges are best off in their little ivory tower deciding these cases without worrying too much about the jurisdictional. Now, obviously, you're going to have to get into it from time to time, but the nightmare of the logistics of handling, say, in every case, right, that someone brings up an RPI issue because your Taiwanese subsidiary isn't mentioned here. It really doesn't help move the patentability question forward in an efficient way.
So let me ask you that, and I apologize because this is just sort of come to me over the last this panel, and my conversation with Deputy Director Stewart. How much of this do you think is that, I want to say that the PTAB judges don't really know what they're supposed to do. It's not exactly how I want it to come out. So let me backfill, because I have this in my head, and maybe you all can help me work through it to maybe articulate it even better. I have in my head that with, re-examination, there is a procedure in place where if the director comes across something that they think shouldn't have issued or wanted a second look, director initiated re-examination. So whether a party, the patent owner, a third party, or the director, or whoever sees a problem can say something, get the office to take a second look. And clearly in that process, it seems to me that the focus is on patentability, period, the end, right? We want to get it right. Whoever starts it, patent owner, third party, director, or whatever. And I wonder whether that's really what's going on at the PTAB. And I suspect there will be some judges, and it's hard to argue with this philosophy, that would say, well, yeah, it's the same thing. We were trying to get the patentability question correct, realizing that with IPR, you're not going to consider 112, you're not going to consider 101, but we're trying to get the 102 and 103 stuff right. But then there's this overlay that makes this a mongrel mix, right? It's a contest between two people. If you don't raise the issue, ordinarily in court, the judge doesn't fill in and make a better argument for you than you did. They don't shift the arguments for you. And now we have the Supreme Court saying it's all or nothing. So yeah, the statute says one or more, but like if there's 20 claims being challenged and there's a question about one of them, but 19 of them, there's no question, given that it's all or nothing, it would seem to me logical that that would influence people's decision on whether to institute. So it seems like with what's going on at the PTAB, that there's something different or potentially different philosophically than just the patentability question. And I don't know whether
at the PTAB, do you mean at the PTAB or at the director's office? Because
I mean the whole thing, the whole shooting match. And that's where I go. So let me go back to what I said. I don't know that people know what it is that they're supposed to do. And it's not meant to be a cut. What it's meant to be is like, have we really defined enough about what this process is? Is it a patentability question? Is it the judges are being the judicial referee and deciding on the two things that come before them from both parties? Is it a little bit of both? And I don't know the answer to that question, but maybe you guys do.
Well, all of this tends to go towards whether or not the judge can even decide the case, right? The RPI issue, naming the real parties of interest, is so a judge can go, oh, crap, I have a conflict. I shouldn't be on this panel. That's what that is for.
Right.
Principally, it is not for someone else to say you forgot a subsidiary. Okay, that's
well,
really
no,
not
and see
what
that's also, I mean, because certainly in the ex parte board, that's the whole reason for it, right?
Yeah.
But as I think Tim brings up the interesting point that there's more than just that when you're at the PTAB, right? Because it is in the statute potentially, and I guess I get back to I think we don't have our hands around what it is that we're really trying to do. Tim?
Right.
I mean, I think, like, take RPI, for example. The in re-exam, you just have to certify that you're not stopped, right? You don't have to,
Right.
you don't have to try to identify, you don't even have to identify who's ultimately funding the re-exam, but you do have to certify that you're not subject to estoppel, right? That you didn't do an IPR and for example, and lose, and now you go, oh, gee, let me file a re-exam. Well, you can't do that, right? So it's a little bit simpler in re-exam because the rules are geared more towards, I think, there's less discretion involved in re-exam. Really, it all comes down, is there an SNQ? And if there's an SNQ, then we're off to it's examination, right? At that point,
Mhm.
it's ex parte and it's examination. And yeah, there's a possibility for a director to get involved, but I think other than one or two cases,
It doesn't happen
per
often.
decade, it's pretty rare. In PTAB, there was a lot of, early on, there was a very high institution rate, and there was a lot of repeat challenges, and there were a lot of, like, people would say, okay, I can flood the zone and I'll file 8 petitions challenging one patent. And over time, a body of precedent was built up, made precedential, that limited things like serial petitions by the same party, expanded to parallel petitions by the same party, and even the example you mentioned, one claim out of 20
Mhm.
is challengeable. There was even precedential decisions on that, saying that when you make the binary decision under SAS that the Supreme Court requires, you can deny for discretion, saying most of the claims
Right.
appear to us to not meet the likelihood standard, so we're not going to institute for one claim. I forget the name of the case. I'm sure
Right.
my colleagues will have, especially Scott, will have it on the tip of their tongue. But they,
Just Scott, I want you to remember, it was not me that put you on the spot there like that. That was Tim.
I
It was
feel
Valve.
we no
Balance.
longer have to sit around the table, and so I'm not worried. So, but by and large, the policy decisions were made through the precedent to kind of take those issues away from, the judges doing their job of just looking at the
Right.
patentability. And so, other than you'd follow general plastic, if this was a serial petition, you'd follow trial practice guidance. If this was a parallel petition situation, you'd follow other precedent. If this was a 19 out of 20 claims appear patentable, so we're not going to go. There were ways to kind of mitigate, I think, some of
Mhm.
what we're seeing as maybe the worst aspects, or the most infuriating aspects to the patent owners.
Okay, so what I'm hearing from you, Tim, and Jay as well, is that essentially, okay, so the judges, they do understand what they're being charged to do. It is really, from their point of view, a patentability question. And then there's these other process administration from justice concerns that so I guess maybe my concern or issue is with all of this is that have we really articulated what it is we're trying to accomplish? And I guess I'll come back, and I want Scott, you and Jen to chime in on this too. Have we accomplished that in light of the fact that this is not ex parte? Because so much of what the patent office does is ex parte, and this is not ex parte. It is a fight. Jen, you want to go first, and Scott?
So I just, as from the judge perspective, I just want to say that when I was at the board being a judge, our goal was to determine patentability. That's really what the judges want to do. That's what they're there to do. Things like discretionary denial and RPI are kind of way outside of our wheelhouse and get frustrating. And especially when the rules change constantly about things like that, it's really frustrating. And I was always happy. Great, the director's going to decide discretionary denial. Great, I don't have to decide that. So I think that the judges are all kind of on board with that. But the point is that it is a fight between two parties, and other things are going to come up. Lots of questions that we never predicted would come up, like there was the sovereign immunity question that came up. And so I do think the judges that we have are good lawyers and are able to deal with those kinds of things. But it's helpful if we decide the issue once and, like Tim was saying, make a presidential decision and then move on and go to patentability. But what we're changing a lot of here is the non-patentability issues. And when they're changing a lot, that makes it hard for everybody.
Mm-hmm.
So.
Okay, great. Scott, you're a lot on the table. You can react to anything that you'd like to.
So, hat tip to Kevin Cherry for this, but the answer to Tim's question was Chevron and Deeper are those two cases. So, but yeah, I do think that the judges really want to be doing patentability, and I think that's what Congress wants people to be doing is patentability. They put in these guardrails and things of RPI and things, but they really, I think, or I always thought of it when we were trying to enforce the non-reviewability of institution decisions was, let's have someone enforce the guardrails. The Congress has said that's the director, but once one of these things is going, all we care about is patentability or not. That's the real issue. That's what these IPRs are really about. Are the claims patentable? Are they not? Let's not have litigation be all about these sideshows about whether or not the thing should have been instituted. Litigation should be about whether or not the office got it right, saying that these claims are patentable or saying that the claims are unpatentable. That's really where all of this is supposed to be. But the interesting stuff, because the non-reviewability of denials of institution makes them a very powerful tool to do things that the director wants without any review. And it's so the focus has become away from the patentability focus, and now it's what can I do? This is sort of back to what I said early on. I'm going to ignore that 70% of these things are no good on average. I'm going to say I just don't want to look at them. And that is the wrong way of going about it, in my view. And I think that the judges certainly care more about patentability. They love getting into the technology, getting into the patent law. That's what by statute they're knowledgeable in the law and in technology, and that's what they love doing. They love rolling up their sleeves and figuring out, you know, was this an obvious innovation or not? And they spend a lot of time and effort on that, and they'd really rather be focusing on that. And I think Congress wants them to be focusing on that as well.
Okay, excellent. So we are at time, but I want to give each of you an opportunity, if we can do it in really rapid fire way, to give your final thoughts. What do you hope the audience leaves today remembering? Jay, maybe we could give you the first final thought.
I would really like to see more transparency in the decision-making process. Right now, there's a black box. You need to have the reasons there. The PTAB has always been, well, even when it was the BPAI, it's always been known for writing lengthy, thorough decisions explaining the rationale behind why we did what we did. And just by and large, those decisions have withstood the test of time and the test of review. And that, the judges just want to determine the facts in the law, as Scott and Tim and Jen have even said and I think we should let the process operate transparently and with the thorough record being developed, and not because you can get into a shenanigans situation where you have a director who might just say, well, Tim Fink was in the Blue Man Group, and I hate the Blue Man Group, so I'm not going to institute. And there's no check on that, no check at all. So,
well, I personally think that was one of the biggest mistakes of the AIA. Is I'm not a fan of making anything unappealable. There's got to be a check somewhere, somehow. But all right, Jay, thanks for those final thoughts. Tim.
Oh, that's easy. If you have to walk away with one thing, I hope you can see that all of as to my former colleagues here, that we all had a lot of respect for each other and the institution, and we're very dedicated. So not just this panel, but the last panel.
Great, thanks a lot, Tim. Scott.
Yeah, I'll second that. I think that the judges are hardworking, thoughtful people who want to do what's right, and so much of the argument is about tearing them down, and I don't think that's appropriate. I think what we need to do is focus on patentability. I'm disappointed that the focus has gone away from that. Maybe that we could do something better to make the claims that issue better. Maybe we should say that I think it's great to limit it's multiple bites at the apple and things, but just to ignore the patentability issue and get rid of those and say, oh, I'm helping the patent system, seems wrong-headed to me. And I hope we return to a place where we have these expert judges just deciding patentability and making their decisions and having them be reviewed by the Federal Circuit and generally being told they're getting it right.
Great, thanks a lot, Scott. And the final word, Jen, goes to you.
I would just like to say that I think that the board, they really gathered a lot of really good people together that are really good at determining patentability, and I'm afraid that it's going to dissolve. And no matter what, I think we need people that are good at patentability at the Patent Office. So I hope that doesn't happen.
Excellent. Well, thank you all for your insights and opinions. I think this was a fascinating conversation. I really appreciate it. And you've all in the audience successfully completed an hour of CLE. We went over just a little bit, which it counts for any of the intros at the beginning. So you got a full 60 minutes. So thank you for being here. We hope you will continue to join us throughout the day. We're now going to take a lunch break. We will be back at 1:45 with our views of what's happening inside the Beltway. So hopefully we'll see you back then for that panel, but that's all we have for now. So we'll see you soon, everyone.